Good evening. We're going to be talking about today the interfiling process versus the adjustment of status process. It's which one will be winning.
Somebody saw my thumbnail I created.
I love your thumbnail. It's a great one. So we're going to figure out which one is good for you because everybody's different. We can also talk about the Build Back Better Act, where it stands and where it's heading, and whether the legal immigration provisions 60,002 and 60,003 still remain intact. Without further delay, I am Sam Shihab, and my colleague
Brian Burke. Hello.
We are with the law firm of Sam Shihab and Associates. We're immigration attorneys, and we like to share every week, every Monday at 6 p.m. An hour with you to talk about immigration issues and current events. Brian, which of the two would you like to tackle first for us?
Build Back Better Act, I think.
All right.
So
let's do it. Build Back Better Act.
Build Back Better Act. You say it fast. It's fun to say. It kind of rhymes. I love saying it.
Yep. Where does it stand?
So last we talked, it had passed out of the House. We were very happy about that. And then it was, it's going to be taken up in the Senate. Question one, has it been taken up in the Senate yet? No. I was just reading the Senate's agenda, the calendar for today, what they've been up to. They were on a defense spending bill, which I understood was a priority for them today. So no, they're not. You're not missing anything by not turning on C-SPAN right now. They're not debating it. They're not talking about it. However, negotiations are ongoing. I've been sort of reading the political news today, and it's what are the sticking points? Well, in the Senate, they need every senator to pass it, right?
Democratic Senate.
Every Democratic senator. It's not anticipated that any Republicans are going to cross the aisle to support it. So what are some of the sticking points? I mean, it's the names you've heard before. It's Joe Manchin, Kirsten Sinema. A couple of the sticking points on the bill in the Senate are paid leave, immigration benefits for the undocumented, and I heard something about Bernie Sanders wanting to add more to the Medicaid components of it. So these are the things they're probably talking about in the background right now.
But not a whole lot of noise about legal immigration.
Yes. My litmus test is if I Google immigration and, the bill, what do I see them talking about? And it's always about the undocumented, whether it's the parliamentarian's going to allow it, et cetera, et cetera.
Yeah. And let's go through this one more time so everybody knows what we're talking about. In this bill, the Build Back Better Act is a 1 million green card recapture from 1990. It is the first attempt to recapture visas since 2005. What is recapture visa? Recapture visa is the unfortunate situation that happens every year and yearly since 1990, where the government, USCIS or INS before them, approve less green cards than they are supposed to approve, and the State Department, less green card than they're supposed to approve every year, thus wasting green card. That's called wastage. And the bill is to recapture, meaning to reclaim these lost green cards. Obviously, this has been going on for every year since 1990, but because of the pandemic, we've had a massive wastage in the last couple of years that prompted a look and a corrective action. So we are trying to reclaim 1 million green cards or permanent residencies that have been lost.
Yeah.
About 450,000 of which are
on the employment based.
Based.
Yeah.
So that is going to cut the backlog probably close to one half, which is
nice.
huge, right?
Yeah.
About time. So that's wonderful news if this continues to be on the right track, as it appears to be right now.
Yeah.
Good. All right, wonderful. So we are going to also be doing something new soon. We are going to get you involved in our presentation. We are going to ask you to share their experience, whether it is an adjustment of status interview, whether it is a site visitation, or another scenario that we think is peculiar and interesting that is worthy of sharing. Obviously, we are careful in how we share this information. So we're kind of working on it. We have a couple things in mind that's coming down the pipeline.
Yeah.
But without wasting too much time here. Let us jump into the interfiling versus the adjustment of status.
Yes.
Which one wins?
My imagery.
Round one.
Round one. I like it. Carry the metaphor.
Yes.
What do we think about when we're talking? I got to say, Sam, this is a conversation I've had with a lot of people. People are calling all the time asking about this.
It is very, very intense conversation. Yeah.
Yeah.
Absolutely.
So I have some lovely. Oops, don't want to do that. Talking points, the costs.
Yes.
So
Yes.
what we thought we'd do is we talk about issues, interfiling versus adjustment, and
Round one, cost.
cost. Yes,
Interfiling wins.
gotta agree with that.
A technical knockout. No.
Well,
By points. There's round two.
you're losing me. I like boxing, Sam. You're losing me in this metaphor. So interfiling, your
Yes.
cost, your government filing fee is zero, nothing.
Yes.
Adjustment of status, filing a second set of adjustment status. It is $12.25 per an adult. A little bit less for your kids filed with you.
$750 for the children.
Yeah, it's a little bit painful.
Yes. Plus the attorney fees.
Yeah, plus the
time.
Yeah. Now interfiling has attorney fees as well, but how a good well drafted interfiling request can cover your entire family.
Yes.
Yeah. So that's really it.
So on the cost, interfiling wins over adjustment status, hands down.
Yeah.
No attorney fees. Well, some attorney fees, but substantially less. Let's face it.
Yeah.
If you have a family of 5, that's a lot of money.
Yeah.
Filing fees and no filing fees whatsoever. All right. Good. Round two.
Bing, bing, bing. So that's my bell noise. I have no sound effects.
Yes.
So notice.
Yes. Notice, obviously, adjustment of status is superior to interfiling.
Yes.
It basically you pay money and you receive a document from USCIS I-797 notice of receipt, and you can track it. And there's a tracking number, and also there is an appeal process.
Yeah, you can call USCIS and ask about your case. You can you have a reference number. You have something you can talk about. It's really interfiling. Now we got to talk about the interfiling half of this. What kind of notice do you get for interfiling? Nothing.
Yes.
Is it possible to confirm that the government has received your interfiling request? Yes. You can call USCIS. You can call their 1-800 number and ask them about your interfiling request. And even though I'm always skeptical of calling USCIS, people usually get some sort of answer. Yes, we have your request, but the status of it,
I have a feeling we should show the chart with all the options first.
Okay, we're gonna
do that. Let's jump into that so everybody look at it and see where we're heading, and then we can probably yes. So let's go over those quickly. Yeah, let's go over those very quickly.
Yeah,
and then we can talk about them.
Certainly.
So we're going to talk about cost. We're going to talk about notice. We're going to talk about discretion, and we're going to talk about peace of mind.
That's one of my choices, Sam. It's a soft and fuzzy one.
Absolutely. We're going to talk about protection, flexibility, and then speed in that order. And that chart, round 1 and round 5, if I'm counting quickly, 6, I'm sorry, interfiling wins, 2, 3, 4, and 4, and 5, round second, the adjustment status wins, and then speed, we're going to talk more about it and see.
I have question marks there for a reason, Sam. I think it's the most interesting one, and it's kind of one of those crystal ball questions.
Yes. All right. Sounds good. So this way, give everybody an overview of where we're heading.
Yeah.
All right. Wonderful.
So we talked about notice. We're good on notice.
Well, let's see. What else on notice that you think is important? Don't you think that with interfiling, if you couple it with a supplement J, you can get sort of a notice?
Well, yeah, to bring everybody up to speed, it's possible to send a supplement J with your interfiling request, your transfer of underlying basis request. I should have called it tub in the presentation name, Sam. I digress. It is possible to send an I-45 supplement J along with your interfiling, your transfer of underlying basis, and if they will send you a receipt notice for your supplement J. So if you get that receipt notice, Sam, that means they received your interfiling request, and it means they got that envelope, right? They did something with it, right? However, I still don't know if I feel very, very good about it, because I feel very good that they got my supplement J if they send me a receipt notice, and I just worry they tossed the other half of it in the garbage. They said, "Oh, cover letter for supplement J."
Can you find a spot in one of the boxes to add interfiling included? Supplement J within the form somewhere, when they say job description or somewhere, you can just throw in that 3 words. It doesn't hurt.
Yeah.
But it doesn't really change the fact. It's really not a notice.
You can't get there's no receipt notice for the interfiling transfer on an underlying basis.
Yes.
End of game.
Yes.
Yeah.
All right. Sounds good. So round 3.
Yes, sir.
Discretion. Yes.
Yes.
Now both are discretionary, but it's a comparison between a model airplane and a real airplane. One has a whole body of law around it to protect you, and the other one is very flimsy.
Yeah, if you go read the interfiling rules, they basically says, okay, we'll take your interfiling, your transfer underlying basis request, but if we think your case is too far along in the process, or there's a bunch of other factors, on this as well, we can basically say, no, you're going to stay in that category.
Well, not only that, but also, they're known to lose stuff.
Yeah.
Right?
Yeah.
They lose stuff, and they can say, oh, we'll just exercise our discretion not to do it. They don't even have to give you a reason.
Yeah.
They don't even issue a rejection.
Yeah, and that brings us back to the notice part. You don't get it when there's no receipt number. There's no obligation to send you a formal decision notice on the case.
Mm-hmm. Yeah.
So,
which is annoying.
Yeah, really annoying. And it's all wrapped in this notices. People who we have pending interfiling requests, we warn them about this, and we're telling people right there, is it drives them a bit mad that they don't get any notice.
But it works, right?
It does. So on the other side of the coin, USCIS, Sam, does USCIS prefer interfiling requests?
Looks like they do.
Yeah, they don't want a second case. They don't want to.
Although it's money for them.
Yeah, money for a case, and knowing that one of them they won't have to adjudicate sounds pretty good.
They're just incapable of handling it. Their system is incapable of handling it. Both the State Department and USCIS, they're just not able to handle interfiling, and that's an issue for them from a procedure standpoint. But back to discretion, adjustment is discretionary, interfiling is discretionary, but it's a huge difference. Adjustment of status, there's an appeal process, there's memorandums that they have to follow, and you can file motions, you can appeal. With the interfiling, I don't think there's any body of law that supports anything like that.
Well, as an attorney, it sounds as soon as you start saying that you can't appeal it, I say, oh, I bet I can, Sam. But would it be an absolute nightmare and pain to do? Yes.
Well, if there's no decision,
there has to be a decision.
The only decision is to approve the prior petition.
Yeah, and
you have to appeal a negative.
Yeah, you
have to appeal a vacuum.
Yeah.
And you know how tough that is?
Oh, incredibly tough. Fun immigration lawyer challenge, practically speaking, nightmare. Yeah.
All right. So discretion, adjustment of status wins.
I gotta say, one less layer of discretion upon. You still have to deal with adjustment of discretion, and there's
Yes. All right. Okay. Well, peace of mind. My goodness. That's a no-brainer, right?
Yeah, as I was saying earlier, there's people out there who we know have pending interfiling requests, and what are they going to do? What are they going to do? When are they acting on it? What are they doing about it? Now, it's not as if USCIS is 100% transparent, Sam. You don't know what they're doing on your adjustment of status case at any time, but I think this kind of links back to the notice requirement that at least you have a case you can call about, and they can tell you it's moving forward. You can see how long they take on that sort of case. USCIS publishes their I-485 processing times. They publish a point where, if you're beyond this point, you're beyond normal processing times. You can call your congressman with the receipt number, and there you go.
Absolutely, and linked with the peace of mind is protection, which is your next point. But as a segue to peace of mind versus protection is the resetting of the 180 days.
Yeah.
Which is a huge issue with a interfiling transfer underlying basis. You cannot move to a new employer after you send your interfiling until you wait a fresh new 180 days.
Yeah.
Which is a major. I mean, you can, but I guess you cannot claim it.
With it. Yeah.
Until 180 days pass, you're exposed.
Yeah.
All right, sounds good. So peace of mind, who do you think wins? I think unequivocally the adjustment of status wins.
Yeah, I feel good about something I can, wrap my hands around, and I know that if I get just as an attorney, if I get a receipt notice in the mail, I say that case is good. I like that case.
Well, I think so. So on the protection next, so adjustment of status wins on that one, hands down. I
Next,
think.
yes.
So protection is huge too for adjustment status.
Yeah.
What's your first point on that?
Well, we talked about the topics we wanted to talk about. But when I thought of protection, I thought of you have a second green card in process, meaning if something falls apart with about one of your I-45 cases, you might have another one as a backup. That's the number one thing that crossed my mind.
Well, I mean, protection for me is more than that. The protection for me is you have two cases.
Yeah.
Going on with a tub. You've given up a path to pursue a different path. So now you are in the EB3, you do an interfiling, you've abandoned your EB3, and you go on the EB2 route. And if the EB2 got ahead, EB3 got ahead in the future, you are not allowed to go back with an interfiling.
Yeah.
Right?
Yeah.
But you can go back with another adjustment filing.
Yeah.
Right?
Yeah.
So that's doable. So again, you're back to the adjustment. So for me, in terms of protection, if you have a system by whichever one is current first, you get the green card, that's substantially more protection for you.
Yeah. I mean, yeah.
Secondly, the resetting of the 180 days. So you have an EB3 and you do an interfiling 6 months later into an EB2, you cannot go to a new employer until a new 180 days have passed. Whereas if you have an EB3 and you do another adjustment of status in the EB2, now you have two of them going at the same time. Now, let's assume 3 months into this EB2, you're forced to change employers for whatever reason.
Mm-hmm.
Maybe this one is at risk, this EB2 is at risk, but not the EB3. The EB3 is in good shape in terms of going in, filing supplement J, and going on, you're protected. And that gives you a lot of opportunities. So in terms of protection, filing a second adjustment of status give you a massive protection. And obviously, clearly, for the above reasons, which is the peace of mind and the discretion piece, you are a lot more protected because you get a receipt notice.
Yeah.
So for me, an adjustment of status is substantially more protective of your right than a transfer basis.
Yeah.
All right. So which one wins?
Well, got to be the second adjustment status.
Yeah, it wins. So check. So round what, 5?
That would be round number 5. Yes.
Okay. So round 5, adjustment status wins.
Yes.
All right. Next.
So filing flexibility, Sam. I had this one marked as in favor of interfiling, but maybe not. So the big benefit of interfiling, well, let's talk about the problem with that second adjustment status is you have to be in valid status to file an employment-based adjustment status application. Meaning, if you took advantage of that green card, EAD, and advanced parole, used them, you might no longer be in status, and thus you are not eligible to file a second adjustment status. It's it's possible to get back in status, but it's complicated. So that's the problem with the second adjustment of status. So interfiling, you don't have to be in valid status to transfer the underlying basis of your adjustment. Anytime you're allowed to do it. there's that. However, as we were going through this conversation, one of the things that came up in my mind about flexibility is you can only do it once. USCIS policy says only one transfer underlying basis, and then you're stuck. And maybe that's not so flexible sounding.
Well, it's flexible, and I mean, I'm going to counter argue here. Flexible in the sense that you can do another adjustment later.
Yeah,
but that is a check mark for adjustment. Sounds like to me.
Yeah.
So adjustment wins. Adjustment comes to save interfiling.
Yeah.
Adjustment is the stronger brother of interfiling. There's no question.
Well, so interfiling. If adjustment's your stronger brother, interfiling's the brother that's always there for you.
Yes.
And interfiling is not going to leave you in the lurch just because you decided to use your EAD.
Yeah.
And so that's why I sort of check that as the winner.
Yeah.
Now, Sam, are we ready for the last of our last of our rounds?
Well, which one? This one wins. Draw.
Kind of a draw. I think the filing flexibility, that's a fun one to say, really depends upon where you are in your immigration, history. What's, maybe one, I think I still got to say interfiling wins there, because you can't really take yourself. No, you can't take yourself away from interfiling. Toss up, Sam. Clearly toss up if I can't even decide amongst myself.
Sounds good. Sounds good. I will relieve you from that pain and agree
no,
with you.
You want me to talk about it for another minute, Sam?
No, absolutely not. It is a toss-up. You've made the case for that, a strong case for it.
Yes.
All right. So filing flexibility is a toss-up.
Yeah.
Excellent. Our next and last round.
Ooh, this is the doozy. They added a couple extra minutes to this round because it's the ultimate crystal ball question, Sam. It's what's faster. I want to hear your take on, because I've been thinking about this one a lot, Sam, and I'll be interested to hear your answer.
Honestly, for me, it's a no-brainer.
Yeah,
it's adjustment.
Why is that?
Because you have the faster of the two.
Well, you have to go back. I mean, here's my counterpoint, Sam. So if you look on the USCIS website and look up how long it takes to get an adjustment status approved, they'll say 10 to 24 months, right? And when you file that second adjustment of status, in that second adjustment status case, congratulations, you're at the beginning of the line in terms of processing time. So there's that. You're looking at waiting the entire processing time of adjustment of status again. And really, this is where it breaks down. Is do you think they can get to that? They can get to your interfiling before they can get to your adjustment of status for going through the whole process once again? And everybody out there who has, I'm clearly fired up about this, Sam. Everybody out there who's had an adjustment status process pending for about a year at this point, more than a year at this point, says, yeah, I don't. Maybe I'm not so believing that my adjustment of status, that second one, will move fast.
Okay, then you make a good case in that scenario,
Mm-hmm.
right? In that scenario, but if you're interfiling with the expectation that you are going to get your green card in 2 to 3 months after interfiling, you're dreaming. You're not realistic.
Yeah, I talked to people. This is something I talked to counsel somebody on very recently. I said, you have this adjustment of status case, which looks normal, and then you say, I'm going to add a whole bunch of machinery to this. Don't expect it to move faster.
Yes, it's not going to move faster, and there's no really good information on interfiling. That's part of the problem with interfiling. It's not even tracked.
Yeah,
that's not even processing time. So to tell me because interfiling is going to be faster than a new adjustment, you're comparing a process that has tons of information on it, which is the adjustment, to a process that has zero information. So for you to make that conclusion,
I'm not making a conclusion.
You can't conclude that.
I cannot conclude. So I can think of somebody I talked to recently who basically said, I have a child who he's locked in under my my EB. He's locked in, and he's going to be locked in under EB2. And I'm trying to get him in-state tuition for college, save him $40,000 for the year. And the question is, what do you think is going to be faster? And that's a scenario where
Nobody knows.
Well, nobody.
I mean, this is the problem with it. So for me to say interfiling is faster because you're going to not start from the beginning. We don't know.
So it is.
Now, on the other hand,
It's a bet.
On the other hand, you can do an interfiling, and 5-6 months later, the other process is faster.
Yeah.
So in terms of speed, which is your provision, right? If you lay out the 100 different scenarios, okay, 100 different people going through this interfiling, and another 100 people that go through the dual adjustment, I would say more than 50% of them will be faster in the adjustment route.
Yep.
Because you have both direction. I think it's going to be less than 50% will be faster with interfiling. And therefore, clearly, for me, now, I'm not saying adjustment status is faster, a lot faster, because there's no information on how fast interfiling is.
Yeah.
But what I'm telling you is that the common sense analysis tells me when I have two horses in a race, okay, versus one horse is going to jump to the other track and finish quicker, that scenario is not half the cases. It's less than half the cases, for sure. I'm comfortable in that assumption.
Yeah.
And therefore, I think a dual adjustment will get you there faster on average.
Yeah.
And that's my case for the adjustment.
Yeah.
I'm comfortable with that analysis.
I think on average that's wise. If you need, I mean, basically, if you need the chance that it might go faster, it's an interfiling request.
Yes.
But
so in terms of which is faster, I think, and then I mean, honestly,
ultimately it's a crystal ball kind of issue.
I don't think it is a crystal ball kind of issue. I think it's a very analytical because you have two races going at the same time. The chances of you being faster doubles. The only scenario in which you could be slower is if interfiling can be picked up and closed longer than a new application. We don't know that information.
Yeah, that's really it.
Yeah. So let's throw in that on that screen one more time, and let's go through it and let's talk about where scenarios where really interfiling is better for some people, whereas and we get 3 minutes real quickly here.
Yeah.
So cost. If you are financially limited and cost is a big deal, interfiling.
Yeah.
That's for you. So we talked about what is better for you. We want to talk about what's better for you. So if cost is an issue and you don't mind, there's no notice, and you do not mind that you could be going to chase it sometime, and you really, you're taking a little bit, rolling the dice on speed a little bit. So, cost is a big deal for you, interfile.
Yeah.
Don't adjust.
Yeah.
If getting a notice where you get protection from the government giving you the ultimate runaround on your interfiling and not knowing where you stand, then file an adjustment. That's a big deal, and where cost is not an issue. If you're worried about the government screwing up, losing the paperwork, you have low confidence in the system, then file an adjustment. If you have a high confidence in the system and you feel that USCIS is going to do the right thing and you're comfortable with that, then do an interfiling. If you are a person that value your peace of mind at a little bit more money out of your pocket, then clearly go with an adjustment. If you value a little bit of a stress, saving money at the expense of a little bit of stress, then do an interfiling. Yeah. Interfiling works for you. If you're the kind of person who is worried that they're out to get you, that this government is out to get you, you need to have a process that would give you the ultimate protection. Absolutely not an interfiling. The ultimate protection lies in a second adjustment. And we're going to throw in the filing requirement, flexibility, and speed toss up. So we're going to take those out in terms of design. It's really kind of a too close to call scenario. So those are the things that we believe that will decide which way to go.
Yeah.
Make sense?
I think it does make sense.
All right, perfect. Well, changing gears.
Yeah, I think
All
it was a good topic. I had fun. I like the format, our chart with all the talking points.
I,
Yeah,
I like it. It's very nice.
Yeah.
Nicely done. So let's take some questions.
yeah. We have some good ones already. Keep them coming
Yeah.
too.
Let's put them on the screen here so we can read them.
Yes. So let's do a little bit of this. Make it a little bit easier for us to read. There we are. So hope the two of you had a wonderful Thanksgiving and some downtime. Well,
I did have some downtime, and for us in Ohio, we watched the Ohio State-Michigan game, and we watched Ohio State lose. I haven't lost in a long time. My 14-year-old was devastated. Well, she wasn't really. She was, okay with it. But my 16-year-old was happy because she's a Michigan fan. So it was a half happy, half sad house.
wow. I caught the Buckeyes loss on Saturday, and then I caught the Cleveland Browns loss on Sunday. So in terms of football, it wasn't a nice weekend, but I had a nice time. Time away is valuable,
Yeah, turkey was good.
Yes.
I'll post my picture with the turkey next time.
So here we are. Next question. So is the debt ceiling linked to the Build Back Better Act, or is that a separate bill? I don't believe that's linked to the Build Back Better Act.
They are linked a little bit, and there is a certain deficit that it's been agreed to
yes,
not to
about
exceed. So and the budget analysis came out that it exceeded that a little bit, and therefore there's concerns, and they want to pull back certain things so they do not exceed the budget requirements that was set forth. The additional deficit. Now I don't have the numbers in my head to mention them off the top of my head. However, there have been some nuanced news and very not. I mean, I'm not going to even quote it because it's not confirmed. That suggested that the legal immigration has been confirmed not to add to the deficit.
Yeah.
Which is common sense because everybody in the U.S. 95% of the beneficiaries of the employment-based green card are
here in their paying taxes. Yeah.
And those coming into the United States normally they have a sponsorship.
Yeah.
So they are guaranteed by other U.S. citizens not to use government benefit by law. Therefore, until they become a citizen.
Yeah.
40 quarters, I think, for 10 years.
10 years, yeah.
Or they become a citizen, whichever occurs first in time. Therefore, it did not create a deficit in the budget. But I don't think there's a formal confirmation, but I think it's common sense.
Yeah. So here we are, moving on to the next one. Well, Sam, it's a Sam question, so I'll allow you.
How long is it taking to get advanced parole after biometric is done? My case is Nebraska Service Center. Well, I think when he says Sam, maybe both of us. But I mean, 3 months? Is this what we're seeing?
Yeah, it doesn't sound
2.5 to 3 months.
Yeah, I mean, well, this is one of those things. Whereas as soon as you state a time frame, it suddenly doesn't apply for somebody's case. Okay. So my advice is, dealing with USCIS on this. It's check their posted processing times, and that's really, I mean, go to uscis.gov. It's about 2/3 of the way down on the right-hand side. Check the processing times for AP cases at the Nebraska Service Center. If they're not meeting their processing times, you put in a service inquiry and try to get them to move on it.
Yeah, absolutely.
Going to keep on moving along here. There's one from Raj.
All right.
So I see on my EB3 I-140 approval notice the SOC code showing 00000 on EB2 I-140 approval notice. No SOC code. Do I need to check with USCIS for the EB3 SOC code? No. I mean, my take is...
Yeah.
So for anybody who has a long approved I-140, look at your I-140 approval notice. There's no SOC code on it. Maybe in the last couple of years, they started adding SOC codes. And
it probably has to do with the supplement J issues.
yeah, you're so they can easy point of reference to see if you're in the same or similar job for the future. But no, it's not something I'd be particularly worried about.
I mean, if you are using supplement J, they're going to have to go back and look at the file, and they're not going to decide a supplement J from a code. They're going to look at the job descriptions, both job descriptions, and see if they are same or similar.
Yeah. So it doesn't surprise me that they're showing 00s as SOC code, but it doesn't concern me either, I guess.
But I'd like to kind of take this opportunity by highlighting that the government, they do screw up sometime, and that's why I'm not a fan of transfer underlying basis.
Yeah.
With something there's no documentation behind it.
Yeah.
The whole idea is ridiculous.
Yeah.
Sorry to give you my unedited opinion on this issue. I mean, you go through a legal process where they have a policy published, but they're not going to give you.
We'll take care of it.
Yeah, we're not going to give you any confirmation.
We'll get back to you. You know, if you have a contractor at your house and he said, "I'll see you when it's done." No.
Don't call us. We'll call you.
Yeah.
When you
That's
hear
really
that,
what it is. Yeah.
Yeah. When you hear that, you know that they don't care. So I mean, it's a ridiculous process.
Yeah.
And it's your green card, it's your family, it's your future, and you've been working on this thing for so many years. And now there's a process in the law that allows you to do something which benefits them, because obviously it facilitates. They don't want you to file another adjustment because their system is so broke that they cannot accommodate it, or it's kind of awkward for them to accommodate it. So they say, well, we'll do a transfer, but we'll do it. We're not going to tell you when we're going to do it, and we may not do it, but we'll try. Yeah. We'll let you know.
So, next question from Syed, a two-part question.
Okay.
So, my current company is not filed perm. My priority date is current. Previous employer withdrew my 2012 I-140 while will H-1B extension using my withdrawn I-140 since date is current. So basically, I think the question is, can I extend my H-1B based upon that withdrawn I-140?
Because the current, I don't think he can.
Well, depends on when the I-140 was.
It's a priority date. He's giving you a priority date, and he told it's current. So based on that, per the 2017 legislation, you cannot extend beyond 6 years because the H-1B is current.
Yes.
So the I-140 cannot be used as the basis to extend.
You may be able to extend based upon your perm.
Yeah.
However, that I-140, the I-140 associated with that perm is no longer out there, so that's kind of no longer approved. Yeah.
So yeah, that's a problem for you to extend your H-1B. So that's a two-part question. What's the second part?
Let's skip a question and get to Syed's second part. So if my old employer hires me back, would we have to start the process for perm or I-140? If I-140, how long would it take for normal process? Any rule? You only have 1 year to file I-45, if not my perm.
Well, a bit of good news.
Yeah.
Right?
Yeah.
I got a good news for you. You can certainly refile your I-140 with the using the perm, and assuming there are no financial ability issues, you should and you should immediately move to file your I-485.
Yeah, you can file that I-45 simultaneously.
Concurrently.
Yeah.
And apply for an EAD, and hope that the I-140 financial ability is not a problem, and you're back in business.
And you get that pending I-45.
Since you cannot renew your H-1B beyond 6 years, so you got to act.
Yeah.
Absolutely. I don't think, or if you have time on your H-1B, if you have 2 years left, there is time to file a perm and a new I-140, and don't claim the old priority date initially, so you can get beyond 6 years, right?
Yeah.
Or you can claim that and file an I-140, I-45 right away. So if you have time, you can still do it with the current employer. If you are not trusting the current employer filing it, and you do not have time, you can definitely revisit the old one.
Yeah.
All right.
So a question I think is pretty good. What's peace of mind? And this is from back when we were talking about interfiling versus adjustment. What kind of peace of mind can you get from anything with these EB2 and EB3 dates keep flipping?
Fantastic question.
Yes.
We're going to give you a fantastic answer.
Oh, well, it's going to be fantastic. I'll let you do it, Sam.
Well, obviously, the peace of mind is you have two horses in the race. You have an EB2 and an EB3. So they can flip it all day long. The one that gets ahead is the one that you use.
Yeah.
Whereas with a transfer underlying basis, you commit to one track. And if it flips back, you're going to say, oh, gosh, I'm on the wrong case.
Why did this? Yeah, why did I choose? Yeah.
And then it flips back again and flips back again, and you're going to be on the roller coaster. Whereas with two adjustments, you have a better peace of mind. But if I understand your question, there's no peace of mind through the labor certification and the green card process. Overall, I understand.
Yeah, the peace of mind comes when you have the green card in your hand.
Honestly, the peace of mind is when you have your citizenship.
Yeah, no,
that's really where the peace of mind begins. True peace of mind. But a green card is a nice spot to be.
Sam, mine comes in pieces, so I think you get a little peace of mind if you get that green card.
Peace of mind.
You get the whole mind when you get that citizenship.
Okay, I agree. That's a good way to say it.
I'm really just brutalizing that metaphor. But
absolutely, yes. But clearly with two adjustments, and especially with the system of counting that they have, which is basically truly unpredictable. I mean, we've seen Charlie that came out and say, "Oh, I'm not sure we're gonna even have any movement next month," and then boom, 6 months, or "Oh, we've moved it a year, 2 months later, boom, retrogressing." I mean, that system is just so unpredictable. It doesn't make any sense. So put two adjustments and forget about it. And that's my opinion.
All right.
All right.
So here is a question that really strikes at the heart of the matter from Sweet Sellers. So it's, if somebody qualifies for both interfiling and refiling, second filing, what option would you suggest? Can they do both interfiling and refiling?
I like that question. Well, no.
So let's imagine. So if
you do interfiling and refiling, it's almost like spinning around yourself in circles, not moving forward whatsoever. It is almost like putting in a positive charge and a negative charge together. Create a lot of spark, but doesn't do anything.
I was going to say
another metaphor.
I was going to do the classic, machinery. It's throwing all sorts of monkey wrenches at everything in the machinery. It's okay. I'm transferring underlying basis. Then I'm throwing another adjustment at it. To what end?
And if you're a mechanical engineer, it's almost like putting the car on first gear and reverse at the same time.
Oh, you can't do that, Sam.
But that's why it doesn't. That same thing.
Yeah, no, you literally can't. You literally can't do that. I'm thinking in terms. No, you literally can't do that. Yeah.
We're just trying to come up with an idea, but
I have a car with a manual transmission, Sam. I just wasn't thinking. Okay.
Yes. All right. So yes, interfiling and refiling, it doesn't work because it doesn't work.
Yeah.
But good question. I like those creative.
No, yeah, people. No, these are questions we get asked a fair amount.
Yes.
So, from Manoj K, I first filed I-45 as EB3 downgrade with me as my primary. It passes my derivative. If my spouse travels and uses AP to continue work with the same H-1B employer, can we file a second EB2 I-485? So, that's really the great question, Sam. I think it's, if you travel and use that advanced parole to re-enter the United States, do you enter as a parolee or do you enter on H-1B status?
No, you enter as a parolee.
Exactly. Yeah.
And if you enter as a parolee, you really cannot file your adjustment. But he's
leading us to a good solution to this for sure.
Yes. And what's that good solution?
It's once you get back to the United States after traveling on advanced parole, you file an H-1B with that same employer to resume your H-1B status.
But you gotta file this H-1B,
yes,
and you gotta get it approved. And once it's approved, then you can file your adjustment.
Yes,
not before.
Well, I never say never. You in theory could file it before that H-1B is approved, but they won't approve your adjustment of status unless they approve your H-1B. And considering you can get premium processing on the H-1B, why would you bother?
Okay, I will take that, but I will counter argue that it's risky.
Oh, yeah, it's risky. Yes, if you're, why would you risk your adjustment status on that H-1B?
But if there's a window of a visa availability,
yeah, that's a good point.
Leave the country and come back on H-4.
Yeah.
File your adjustment, or come back on H-1B. If you're rush for time, or if you want to take the risk, I guess as long as you understand the risk, I'm okay with it.
Yeah,
I have no problem with people
that's
taking.
what we do. We advise people of risk.
Yeah,
Everybody gets to make their own
yeah,
decisions.
benefit cost,
Yeah.
risk assessment, and then you make your decision.
Yeah.
Okay, makes sense.
So, when will EB1 spillover flow to EB2, assuming EB1 has enough numbers?
Well, EB1 does have enough numbers because that's current.
Yeah.
So it's spilling over, but they do consider the spillover usually at the end of the fiscal year.
Yeah.
So that is when they do it. They don't do it every year, every month, because they have to look at how close they are to the numbers. And then when that's achieved, then it spills over to all the EB2s, and then flows to the most backed up EB2 in that category. Typically close to the end of 2 months before, probably, they start looking at it. But that's the discretion of the State Department.
Yeah.
They're the one who do the calculation.
Yeah. Gonna keep moving on. Sam, let's make this one your question. How about that?
At what point will interfiling and second adjustment status impact EB2? In the next month or two, or towards the end of 2022?
So that's
and second adjustment impact EB2. I don't understand the question. Do you?
Oh, I think so. EB2 has leapt forward. It's now ahead of EB3 in terms of its dates of filing, final action dates. And we know EB2 moved. Everybody presumes anyway, because everybody jumped in the EB3 category.
Well, influence the.
Yeah. So basically, when is everybody jumping back on EB2 going to pull EB2 back?
I see the question. This is a good question, Sweet Seller. So I mean, it's when USCIS decide to communicate this information to the State Department.
Yeah.
So the State Department has no visibility on these issues. They don't know. So they can keep these numbers, moving forward without any problem until USCIS sit down with them and say, hey, by the way, we have so many adjustments that we've approved. We're removing these adjustments.
And to illustrate the point, USCIS, as far as we understand, weren't notifying USCIS of changes from EB2 to EB3 until they were approving I-140s.
Yeah.
So
whenever USCIS believes that they are going to be generous in sharing data sufficient to allow the State Department to make decisions.
Yeah, and when will they do that? When they approve the EB2s? Is that when they release the EB3s, or?
I think when they approve the adjustment, because an interfiling alone doesn't do anything. But whenever they see an interfiling, they're not able to handle it. They don't even have a receipt notice to have a track of how many interfiling they have. Ooh. They don't even know that.
They can't really. Yeah, it's not. One of our every time we would talk about a chat with Charlie, one of our kind of gripes was that the data he got, while he's well-intentioned in explaining where things are going, the data he got clearly wasn't very good.
So Sweet Seller alerted us to really an issue here, that by not tracking it, they are unable to figure out how many.
Yeah.
So interfiling will have zero impact on movement of adjustment,
until they approve the case,
the specific cases. And I think also with unfortunately, with the dual adjustment, it will have an immediate impact, because they report that immediately that there's an adjustment filed, but they don't pair them such that they're going to say, well, maybe we should split them. We have.
Should we take? Well, they don't. We don't know whether they say, "Oh, we got a second adjustment for Mr. So and So. Let's yank him out of the."
Oh, we know they don't.
They can't do that, because he has that priority date could still be current. They could still adjudicate that case.
Or so when you have two adjustments, you're getting two numbers.
Yeah.
You're getting two numbers. They're counting two numbers, and they're not splitting it. They're saying, you know what, half and half. Let's take them half and half. No, they're double counting them. So this is a continuing problem. There's not a point in time in which, this is not like downgrading, where they waited until the I-140s were approved and then they reported.
There's no checkpoint where they can.
The only checkpoint is
approval. Yeah.
Adjustment approval.
Yeah.
So that's the
womp womp. Yeah.
Good question, Sweet Seller.
Yes. So a fun question here. So how many jobs can we work if we're on the I-45 EAD, if we want to stay with the same employer and also parallel work with another employer?
There's no restriction.
How many jobs do you have time for?
7, 8. Well, there's no restriction in as much as I would say it does not appear that you're not really working for the adjustment status employer.
Yeah, you do have to have a permanent offer of employment in the United States with somebody, full-time permanent employment offer.
I mean, clearly, if they look at your tax return and your, let's say, your offered wage is $80,000 with this green card, but your gross income is $450,000 from other work, that's going to say,
yeah,
this is not your main job.
Yeah, I mean, you always in the back of your head, you have to have that, your whole point of this endeavor is, I-140 represents an offer of permanent employment, and your I-45 represents, your intent to, I can't shake hands with myself, it's hard. Your intent to accept that, and if they get the idea otherwise.
Yeah, and then again, it depends on who's reviewing it. And some reviewers are very mechanical. Okay, here's an offer of employment, here's a labor certification, here's I-140. You look in front of me, here's your social security number, here's the application, it's signed, it's feed, here's your green card. And then others who are very creative in the way they analyze things and very inquisitive, and they can cause issues. But there's no restriction if that's the answer you're looking for. But keep in mind that you have to continue to show that your job, your green card, is really your main job.
Yeah. Going to keep on going, moving on with these questions.
Mm-hmm.
So here we are from Ragapati Subarasu. If I file a new AOS and EB2, what are the chances that it will not land in the Texas Service Center? My downgrade AOS filed in the Texas Service Center. So
20% it will be in the Texas Service Center. I think it's 4 locations or 5 locations?
I think it ends.
I mean, it's simple as
they end
that.
up in Nebraska, the MSC, and the Texas Service Center. I think it's 3. But ultimately, this is a question we actually get a lot. Somebody doing a second adjustment status filing to say, I want my case to go. I don't want my case to go to the Texas Service Center because the Texas Service Center is slow. Unfortunately, you are limited by USCIS filing instructions as to where you file your case.
And they are going to assign it based on criteria that changes from time to time.
Yes, by
workload, where you live.
Yeah. Workload and where you live are my number 1 and 2 guesses.
And then a random scenario, because if it goes to the room where it's going to go by a guy that sends things to Texas, or it's going to another room who handles other locations, then you're going to go to those other locations. So there is also a random factor probably.
Yeah. Ultimately, you don't get to choose where your I-45 is filed. It's yeah. So coming back, get back around, we're catching up to ourselves. Centaur agreeing with both your answers on peace of mind. Maybe getting the EAD is the first step in the green card and citizenship. Oh, he's talking about peace of mind. I have somebody agreeing that mine comes in pieces: EAD, AP, green card, citizenship.
Absolutely.
Man, they kind of dole your mind out over the course of a long time, Sam.
I mean, it's ridiculous, but hopefully this recapture is going to take away this incredible experience that people have gone through. Probably there has to be a movie done on this, or 2.
Can I be a character in the movie, Sam?
Yes, you can be. You can be.
I can be immigration attorney.
You can be the lawyer.
Oh boy.
You'll do a good job at that.
So, interesting question from Rohit Varma. Do you think requesting a FOIA every couple months after interfiling helps us to find out if our interfiled I-140 made it into the I-45 AOS application file?
Well, yeah, you can, but it doesn't mean that they've exercised their discretion unless they have a stamp on it or something that you can find.
Yeah.
You can do a FOIA every couple months, and it takes a couple months for it to come in. So you can do that, and maybe you will see on it approved or something, right?
Yeah.
Sure.
Yeah, I mean,
a good idea.
Interesting
Yeah.
FOIA.
Yeah.
I mean, I would say be thrifty, let's say, in your FOIA request, because basically they'll put you on different FOIA tracks depending on the nature of your request. Maybe you put your FOIA request in terms of, records of the interfiling
Throw in the
request.
tracking number in the FOIA request.
Yeah, because
It'd be faster.
because if you request the entire file of your adjustment, they will be quick to put you in the complex track, and it might make it take longer.
Right. Just ask for the interfiling documentation in the adjustment file reference number.
Might get you something on a faster track.
pace, yeah.
Is my
That's a good
thought.
idea.
So
All right, I like the idea.
Yeah.
All right, so next one's yours, whatever it is.
Whatever it is, good question. Good question. Hey, good question. So we need to withdraw EB345 application once we are filed for EB2I45. My attorney advised if we don't withdraw, USCIS may withdraw either one, maybe most favorable one, or send RFE, which leads delay.
I'm sorry, but this information is wrong.
I mean, they have. I mean,
there's absolutely no reason they will never withdraw your properly filed I-4. Number one, they cannot withdraw. They can reject, and if they give a receipt notice, that rejection is gone. Then at that point, they are going to either give you a notice of intent to deny or a request for evidence. There's a process. Okay, they don't withdraw your case.
Yeah, and you have the means to appeal that if on the wacky scenario that
in the close to 3 centuries that I have dealt with double adjustments, I have never
3 centuries, Sam.
Close to
centuries,
decades, centuries.
You look really good for 300, Sam.
I am. Yes, thank you. 3 decades. Close to 3 decades, I've never had a single one in which it was denied.
Yeah, I mean, historically, you would occasionally see an RFE that says, possibly get an RFE that says, "Hey, we're going to make a decision. Please confirm you want to go with one of these." But ultimately, your more likely scenario is you get an approval on one, and they administratively close the other one because
only if they get an approval on it.
Yeah.
And I'm going to stand by my centuries.
Centuries,
that's a long time.
Hundreds and hundreds.
That's a long time.
You're an attorney, Sam. You got to watch those things. Hundreds of years of experience.
My goodness, it feels like it.
Yeah. So, what's the status on the Meng Amendment? Is the last question we have here for the moment.
So the Meng Amendment is not dead, but
that's in the defense bill.
But we're talking about that. I don't think USCIS is interested in the Meng Amendment anymore.
Yeah.
Remember why? We talked about
why was that?
The $2.8 billion.
Yes, the $2.8 billion.
So our friends in Congress has threw in the Build Back Better Act a bunch of money for USCIS.
$2.8 billion.
Okay.
That's a lot of money.
That's a lot of money for them. And the Meng Amendment does not have $2.8 billion. So they have a budget. I'm not sure what the amount for the budget is. Historically, USCIS is 100% self-funded, and it is to buy filing fees. So I can assure you that USCIS, which their budget, it was the USCIS or the Homeland Security budget that had the Meng Amendment adopted.
DHS budget bill. Yeah.
So I would say that they're hoping that their budget doesn't pass and the Build Back Better Act budget pass, because it has a bunch of money in it. But it's not dead. It's in Congress. Legislative initiative have a tendency to linger and sit and get ignored and get resurrected.
As I recall, though, our analysis on the Meng Amendment was it takes away some of the visas that might be available for employment, but it's not.
It does not. It doesn't. The Meng Amendment does not move forward any recapture for employment based.
Yeah.
It only does family because it resets the numbers to 0.
Yeah.
Remember?
Yeah.
So the Meng Amendment is not one that we like.
Yeah.
And there's a third one, by the way, that only proposes to recapture employment-based visas. It has a name for it, also sitting out there. But the Build Back Better Act, which is the one that it's Biden's proposal that the Democrat passed in Congress, is the one on the table that has a recapture in it, 1 million recapture, and that's the one everybody's talking about. The Meng Amendment is just
what we're talking about. I mean, it's the one I'm excited about because it seems like it's, again, I've been doing
everybody else is talking about it.
Yeah, it's out there. It seems like it's going to pass. Yes. So, Sam, we're just about at the end of our time. I think this is the point where we won. Thanks, everybody, for tuning in, as always. Appreciate the little thumbs up, subscribes. It's fun. We every now and again we sit down and look up and see who added our channel. It's always fun.
Yep. Thank you so much, guys. Have a wonderful rest of the evening.
Thanks, everybody.